Okay, now we're reading page 932 of Contracts, Chapter 10, Third Parties, Rights and Responsibilities. Section 3, Assignment of Rights. Still, we're reading Sale versus Loan section. Two firms mentioned above, JVS Powersports and Rexford Funding, entered into a factoring agreement by which Rexford received an advance of some $3 million. Rexford does not like business across the United States. In litigation between the two firms, the court quoted as follows from Black's Law Dictionary, saying, "Factoring is the buying of accounts receivable at a discount. The price is discounted because the factor who buys them assumes the risk of delay in collection and the loss on accounts receivable. The accounts concerned were, of course, payment rights arising from the sales of JVS to its customers, the account debtors." Some tension is apparent in the foregoing paragraph, whereas a merchant taking an outright sale of its accounts thereby sheds the risk of non-payment by its customers, or by a disproportionate number of them. In contrast, in using the accounts as collateral for the loan advance, a merchant retains that risk. The parties disagreed about the extent to which the factoring agreement shifted the non-payment risk to Rexford. The term of the agreement, quoted above at page 930, uses the word sells. On the other hand, the agreement assigned to JVS some responsibilities with respect to its non-paying customers. To that end, it defined the word disputes, making it mean any cause for non-payment of an account, except for financial inability of JVS's customers to pay an account at maturity. JVS undertook to give Rexford prompt notice of any disputes and to settle all disputes at no cost or expense to Rexford. Upon a failure by JVS to settle a customer dispute, it was to become liable for all of the unpaid factored accounts. The court considered evidence about a respective non-paying customer and was unsure whether or not the customer's account was in dispute. Hence, it denied a motion by Rexford for a partial summary judgment. Rexford Funding, blah. This happened in 2007 in Michigan. Whether or not Rexford's advance to JVS represented a loan is open to doubt. It might fairly be called a prepayment. JVS assigned to Rexford invoices having face values of nearly $6 million in the aggregate. The case illustrates the hybrid character of many assignments. For many purposes, the sale or loan distinction was reduced in importance by the Uniform Commercial Code. Section 9-109A provides that, subject to a number of qualifications, Article 9, secure transactions, applies not only to a transaction that creates a personal property security interest, but also to the sale of accounts. The comment to a predecessor, Section 9-102, gave this explanation. Commercial financing on the basis of accounts ... is often so conducted that the distinction between the security transfer and the sale is blurred, and the sale of such property is therefore covered. Article 9 applies to transfers of payment rights by way of sales, as well as to those that support loans of payment rights as well as those that support loans. A broadly applicable rule that an assignee's interest is enforceable only if the assigner has authenticated a security agreement. Subparagraph A speaks of authentication by a debtor, but by definition, that word comprises a selling assigner. The rule is, in effect, a statute of frauds. Other parts of paragraph 3 describe some transaction not subject to it. Although the code has reduced the sale-loan distinction, it has not obliterated it. Next section on page 933 is anti-assignment provisions. A contract between a general contractor, Caristo Construction, and a subcontractor, Crew painting contained provision. The assignment by Crew of this contract or any interest therein, or of any money due or to become due by reason of the terms hereof without the written consent of Caristo shall be void. Without having obtained the written consent of Caristo, Crew purported to assign to a bank its right to monies due and to become due under the subcontract. In turn, the bank assigned the right to Herman Alhusin, who sought to enforce it. That action was dismissed by reason of an anti-assignment provision. Alhusin appealed twice without success. The power to contract trumped the power to. The ultimate ruling made in 1952 is cited in the opinion that follows. The enactment of the Uniform Commercial Code superseded the ruling in Alhusin and others like it. UCC 9-406 provides, with some qualification, that a term in an agreement between an account holder, Caristo, and an assigner is ineffective to the extent that it 1. Prohibits, restricts, or requires the consent of the debtor, account debtor to the assigned or transfer of the account. And next page. The terms italicized here are given definitions in UCC 9-102. A. In the opinion that follows, the court considered the possibility that an assignment of contract rights was barred by a provision in the contract that generated those rights. The court did not refer to the code. That omission would be surprising, but for the fact that the rights in question were not accounts, as defined in Section 9-102. A. As defined there, the word is limited, among other ways, to a right to payment of a monetary obligation for goods, for services, or for various other benefits. Hence, the code not have suppressed an anti-assignment provision properly drafted. If buyer of goods to receive delivery, a provision direct at the right of a buyer of goods to receive delivery. That sort of provision appears in Trubowich v. Riverbank Canning Company, a case concerning a large quantity of canned tomato paste. The provision was, and I quote, "This contract is not assignable, and goods sold hereunder are not to be shipped or diverted to any destination other than that herein specified without consent of seller." An anti-assignment provision as follows appears in a standard form widely used for deals in California real estate. Buyer may not assign any rights hereunder without the prior written consent of seller, end quote. The code definition of account does not compromise the principal entitlement conferred on a buyer by the form the right to a conveyance of property, nor does it comprise the seller's principal entitlement, the right to be paid. The three anti-assignment provisions quoted above are perceptibly different in tenor, each from the others. Whether or not they differ in effect should be considered in light of the opinion that follows, which is the case starting on page 934, Bellray Company v. Shemwright, Ltd., and the Jersey Corporation. We're going to read that